Hello dear aspirants, welcome to Epitome IAS. So we are doing the UPSC topic wise PYQ analysis, and today's topic would be Union and State Legislature. It is part 2 of this particular topic from the Indian Polity. So let us start with the today's class. The first question would be, consider the following statements. Statement 1. The Parliament Prevention of Disqualification Act 1959 exempts several posts from disqualification on the grounds of office of profit. Statement 2. The above mentioned act was amended 5 times. Statement 3. The term office of profit is well defined in the Constitution of India. So whenever if you see the third statement, they are saying that the term office of profit is well defined in the Constitution of India. So even though you don't know exactly, you might have known what is office of profit, but you are not well aware of the other facts related to it. Let us say, in that case, if you see the third statement, it is saying the Constitution of India, it has clearly defined the term office of profit. So whenever these kind of statements comes, a particular term is given and they are saying this particular term is clearly defined in the Constitution of India, or if they are saying this particular term is mentioned in the Constitution of India, then you have to like recheck that particular thing. You should be always aware, because in most cases if you see, the Constitution of India does not define the specific terms, like many terms, and in much more cases it does not even mention some of the terms. Okay, so whenever they are saying whether this term is well defined or whether this term is mentioned in the Constitution of India, so you have to, you know, look at it. So the first thing is, this statement is actually a wrong statement. The term office of profit is not clearly defined in the Constitution of India. Okay, so once you eliminate this option, you can eliminate B, C and D, because all these three option contains 3. So you are directly getting the answer A. So ultimately in the exam, what is our purpose? To get the answer correctly. Okay. Even though you don't know the, the facts given in the question, it is important that you derive the answer from whatever pre-existing knowledge you have. Then, if you see the first statement, the Parliament Prevention of Disqualification Act 1955, 1959, it exempts several posts from disqualification on the ground of office of profit. Yes, this is true. The Parliament Prevention of Disqualification Act 1959, it actually exempts many posts, okay, from the term office of profit. Then, second statement, the above mentioned act was amended 5 times. Yes, this particular act was amended 5 times. But when you are in the real examination, any average aspirant or any aspirant who has completed the preparation well, he has completed the basics well, okay, it is clear that even the top aspirants, they can't know, right? The second statement, the above mentioned act was amended 5 times. How can you remember how much time this particular act? It's not very well known act. Some of the acts which are very important, yes, you have to remember how much time or what are the facts related to that. But this act is not well known, much well known, and it is very difficult for you to remember as well how much time it has been amended. So the first two statements are kind of, many aspirants, they don't know what is the, whether it is right or wrong. But here, to solve this question, the only thing which you have to know is the third statement. When you are knowing that, yes, the office of profit is the term which is mentioned in the Constitution, yes, but it is not well defined in the Constitution. This is a basic fact. Agar if you know this fact, you can able to solve this particular question. Okay, then let us go to the next question. With reference to the legislative assembly of a state in India, consider the following statements. Statement 1. The governor makes a customary address to the members of the house at the commencement of the first session of the year. Statement 2. When a state legislature does not have a rule on a particular matter, it follows the Lok Sabha rule on that matter. So, which of the following are correct? So, if you see here, they are talking about the legislative assemblies of the states. So first statement says the governor makes a customary address to the members of the state legislative assembly at the commencement of, the first session of each year, first session of the starting of the year. So is that true? Yes, we all also read this, right? In case of parliament or in case of state legislature, in case of parliament, the president will be addressing the first session. But in case of state legislature, obviously the governor is going to address the first session of each year. So this statement is a correct statement. And if you see the second statement, when a state legislature does not have a rule on a particular matter, it follows the rule on that, follows the Lok Sabha on that matter. Yes, this is true. So whenever in the case of state legislatures, when they don't have any particular rule or regulation regarding a particular matter, what they simply do, they simply follow what the procedure the Lok Sabha follows. Okay, whatever the procedure or the rule the Lok Sabha has, this state legislatures, they simply follow those procedures of Lok Sabha. Okay, so both the statements are correct here. What is the correct answer? Answer is C, both 1 and 2. Then the next question, in India, which of the following review the independent regulators in sectors like telecommunications, insurance, electricity, etc. etc. So statement 1, ad hoc committees set up by Parliament. Statement 2, parliamentary department related standing committees. 3, Finance Commission. 4, Financial Sector Legislative Reforms Commission. And 5, Niti Aayog. So if you see here in the question, what they are asking, in India, which of the following reviews the independent regulators? So what are these independent regulators? Let's say the RBI, SEBI, TRAI. So these are some of the independent regulators, okay, of the government to regulate the agencies or the organizations related to that particular sector. Just like RBI, it regulates the banks in India, right? So these are the independent regulators belonging to any particular sector. So what they are saying is, which of the following these things, they have given 5 statements, 5 options. So which of these following are reviewing, they have the reviewing power to review the independent regulators. Okay, that's what they are asking. So first is ad hoc committees set up by the parliament. So in case of ad hoc committee, they are set up by the parliament to resolve or review any particular issue. Okay, it is related to any particular issue. So this ad hoc committee has the power to review the independent regulators. So yes, this ad hoc committee is set up by the parliament. They can review the independent regulators. Then the parliamentary department related standing committees. So whenever you are reading about this, committees, parliament standing committees, you will be seeing that certain parliamentary committees, they have power to review the independent regulators. Okay, let's say they are making a bill regarding a particular sector. So they'll be having the power to review the independent regulator as well. So we can say yes, 2 is also there. Then 3, Finance Commission. So if you see here, Finance Commission is kind of a, recommending body. It makes recommendation. It does not have the power to review the independent regulators. So we can actually eliminate this particular option. Then once you eliminate this option, you can eliminate B and C. Then 4, Financial Sector Legislative Reforms Commission. So this particular Financial Sector Legislative Reforms Commission has been set up by for the purpose of reviewing the financial legislations, the legislations which are related to the finance. Okay, this reforms committee is actually being set up for the reform of the financial legislations. It does not actually review any independent regulator. So again, this is there, we can eliminate. Then Niti Aayog. So if you see here, Niti Aayog, again, just like Finance Commission, Niti Aayog is a recommending body. It recommends the government. It just has the power to recommend, and whether to accept it or reject it, it's up to the government. So it does not have any power to actually review the regulating bodies, independent regulating bodies. So we can eliminate this option as well. So when you eliminate this option, this D is gone. Correct answer is A, 1 and 2. So in this question also, it is actually very difficult, to remember which particular thing is related, which has power to regulate the, to review the independent regulating body. So the thing is here, the Finance Commission and the Niti Aayog. If you know that these two are a recommending body, they have just the power to recommend the government whether related to, let's say, Finance Commission related to the fund disbursement between the center and the state, and Niti Aayog has the power also to only to recommend. Okay, does not have any other power. Just by knowing this, when you are eliminating both 3 and 4, you might actually get the answer A. So the next question regarding money bill, which of the following statements is not correct? Option A, a bill shall be deemed to be a money bill if it contains only provisions relating to imposition, abolition, remission, alteration, or regulation of any tax. Option B, a money bill has provisions for the custody of the Consolidated Fund of India or the Contingency Fund of India. Statement C, a money bill is concerned with the appropriation of money out of Contingency Fund of India. Option D, a money bill deals with the regulation of borrowing of money or giving of any guarantee by the government of India. So if you see here, they are talking about the money bill and they are asking which of these following is not correct. Okay. So the first statement says that a bill shall be deemed to be a money bill if it contains only the provisions of relating to imposition, abolition, remission, alteration or regulation of any tax. Yes, this is true. A money bill is nothing but it talks about all these imposition, abolition, remission, alteration or regulation relating to the taxes. Okay, so this is correct. This is actually related to the money bill. Then option B, a money bill has provision for the custody of Consolidated Fund of India or the Contingency Fund of India. Yes, this is also true. Okay, this is also considered as a money bill. So B is also correct. And if you see, a money bill is concerned with the appropriation of money out of Contingency Fund of India. Is that so? Usually it talks about the appropriation of money is related to the Consolidated Fund of India. So this is not Contingency Fund of India. Instead, it should have been Consolidated Fund of India. Okay. So if you see option D, a money bill deals with the regulation of borrowing of money or giving of any guarantee by the government of India. Yes, this is also related to the money bill. When the government of India is borrowing any money or it is related to giving any guarantee. Okay, this is also related to money bill. So the correct answer would be option C is the correct answer. Then the next question, consider the following statements. In the first Lok Sabha, the single largest party in the opposition was Swatantra Party. Second statement, in the Lok Sabha, a leader of opposition was recognized for the first time in 1969. Statement 3, in the Lok Sabha, if a party does not have a minimum number of 75 members, its leader cannot be recognized as a leader of opposition. So if you see here, the first statement says, in the first Lok Sabha, the single largest party in the opposition was Swatantra Party. So if you remember, when the first election happened after the independence in 1951, the thing is, when the first Lok Sabha, in the first Lok Sabha, the single most largest party was the Congress. Everyone knows this. But there was no opposition party there. Why? Because to be, considered as an opposition party, there is a criteria. The criteria is minimum that particular party, the second largest party apart from the ruling party, it should consist at least 10% of the total membership of the house. At least 10% of the seats they should be having. So let's say the opposition, the second largest party after the ruling party, it is not having that 10% of the votes and 10% of the seats, then what will happen? There is no opposition party. So in the first statement, they are saying the first Lok Sabha, the single largest party in the opposition, they are talking about the opposition is Swatantra Party. So if you remember, It is not actually Swatantra Party. And to be clear, to be precise, there was no opposition party at all. Why? Because majority of the seats were taken by the Congress. And the second largest party apart from the Congress was CPI. But CPI got only 16 seats. Okay, if you see, for this criteria, they should at least get at least 10 percentage of the total seats of Lok Sabha. Let us say we have 550 seats approximately in the Lok Sabha. What is 10 percentage of this 550? It is 55 seats. So, what I am trying to say is the second largest party apart from the Congress was CPI, and it got only 16 seats. But it should at least need 55 seats to, form the opposition party. So, in that sense, there was no opposition party at all in the first Lok Sabha. Okay, so we can eliminate this option. Then, second statement in Lok Sabha, a leader of opposition was recognized for the first time in 1969. Yes, that is true. In 1969 only, for the first time, the recognition for the opposition party and the leader of opposition happened. Why? Because then only the 10 percentage criteria has been fulfilled, and the leader of this particular party will become the leader of opposition party. So this statement is actually a correct statement. Then statement 3, in the Lok Sabha, if a party does not have a minimum of 75 members, its leader cannot be recognized as the leader of opposition. Is that true? Just now we saw, to fulfill the criteria in case of the Lok Sabha, how much members are needed? How much seats are needed? Tell me. We need 10 percentage, and to fulfill that criteria, we just need 55 seats. But they are given here, and they have given 75. So what is the correct answer? This is wrong. It's not 75 seats, it's 55 seats. So we can eliminate this option as well. For a party, to have a minimum of 55 seats to be recognized as a leader of opposition. Okay, they are saying that in the Lok Sabha, if a party does not have a minimum of 75 members, its leader cannot be recognized as the leader of opposition. So this is wrong. Why? Because for a party to be recognized as a opposition party and its leader to be recognized as the leader of opposition, it should contain at least 55 seats and not 75 seats. That's why this statement is also wrong. So what is the correct answer? Only statement 2 is correct. Option B is the correct answer. So here, if you see the Indian general election of 1951-52 held from 25 October 1951 to February. Okay, you don't need to remember the dates and everything. Just remember that the first, election happened in 1951. Okay, up to 1952. That's it. No need to remember the dates and everything. So this was the first election which happened after the independence of India. We know that. Then, and the first Lok Sabha has been formed. So the Indian National Congress, as I already told you, the Congress won a landslide victory, winning 364 seats out of 489 seats. It got the majority of the seats. And what was the second largest party? It was Communist Party of India, CPI. CPI got the second place, and you know how much seats it got? It got 16 seats. Okay, the Congress got 364 seats, and the Communist Party of India got 16 seats. And to qualify, this is the second largest party, okay, apart from the Congress. So to qualify as a opposition party, it should at least need what? 55 seats. But in case of here, okay, in case of this, total they have 489 seats. So what is 10 percentage of 489? It is somewhere around 48.9. So we can say 59. So around 50 seats. So they should at least contain more than 50 seats in case of this election. So at least 50 seats if CPI would have got, it would have become the opposition party. But it just got 16 seats. So technically there was no opposition party and there was no opposition leader also. Okay. So the leader of the largest opposition party having not less than one-tenth of the seats of the total strength of the house is recognized as the leader of opposition in that house. So according to this, currently they should have at least 55 seats to qualify as an opposition party in the Lok Sabha. Okay. In case of Lok Sabha, whichever house you are picking, you have to calculate the 10 percentage approximately. So it should be more than 10 percentage. So in case of Lok Sabha, it is 55 seats. This is as per Mavalankar rule. So this particular thing, that at least 10 percentage of the seats of the total seats in the particular house. In case of Lok Sabha, the 10 percentage. In case of Rajya Sabha, 10 percentage of Rajya Sabha seats. So this particular criteria is also known as Mavalankar rule. Okay. Then next question, with reference to the Parliament of India, which of the following parliamentary committees scrutinizes and reports to the House whether the power to make regulations, rules, sub-rules, bylaws, etc., conferred by the Constitution or delegated by the Parliament are being properly exercised by the executive within the scope of delegation. So, A. Committee on Government Assurance. B. Committee on Subordinate Legislation. C. Rules Committee. D. Business Advisory Committee. So what they are talking about is basically in the question they are literally talking about the what do you say, subordinate legislation. We may also call this as delegated legislation. What is this delegated legislation? So whenever there is a act which is made by the parliament, which is enacted by the parliament, so in the last few pages, they literally what they give some of the you know procedure or some of the rules or regulations. They'll give the liberty to the executive to prepare those rules or regulations related to that particular act. Okay, you might all know, yes, the legislatures, they make the law. Legislatures, that is the parliament and the state legislative assemblies. Okay, and the executives, what they do, they implement the law. So whenever they talk about the enacting of law, it is made by the legislators. Okay, parliament or state legislature. And whenever we talk about the implementation of the law or implementation of any policy, who does that? You are going to be part of executives, right? So you are going to be part of executives. So the executives, they are going to implement the laws and policies which are enacted by the legislatures. Okay. So there is a clear, separation of power here. That is, the laws are made by the legislature and it is implemented by the executives. But if you see here, the constitution actually provides for something called as delegated legislation, that is subordinate legislation. What happens in this delegated legislation is, whenever an act is made, the parliament itself gives some powers to the executives, the top bureaucracy. The parliament gives certain powers to the executives while implementing these laws, okay, to make any rules or regulations related to this particular law. You can do it. They give this power instead of enacting it properly by the parliament. They just give this power to the executive. Now the executive has the power of kind of making the legislation, some of the part of the legislation or the whole legislation. The act is already made by the parliament, but now the executive have some power to make some rules or regulations related to that particular act. So in this case, what's happening? Parliament itself is giving some power to the executive to make certain, part of legislation. So that's what is happening here, and we call this as delegated legislation or the subordinate legislation. So if you see here, what they are asking in the question is, this particular subordinate legislation or the delegated legislation, this thing, which of the following committee it scrutinizes and reports about the power to make the regulations by the executives. So if you see here, the committee on subordinate legislation, the name itself suggests here. What is subordinate legislation? Subordinate legislation is nothing but the delegated legislation. So the committee on subordinate legislation, there is a separate committee. Okay. of the parliament. So it actually inquires in this particular thing, subordinate legislation. So the correct answer would be option B. Then consider the following statements. Statement 1. The Speaker of Legislative Assembly shall vacate his or her office if he ceases to be a member of the Assembly. Statement 2. Whenever the Legislative Assembly is dissolved, the Speaker shall vacate his or her office immediately. So they are talking about the Speaker of Legislative Assembly. We have state legislative assemblies, right? It is somewhat similar to the Lok Sabha in the center, and we have state legislative assembly at the state level. So the first statement says here, the Speaker of Legislative Assembly shall vacate his or her office if he or she ceases to be a member of the assembly. So this is actually true. In case of a speaker or a deputy speaker, whenever, let's say they are in their particular office, but let's say their particular, seat of the legislative assembly, it itself gets seized, then this particular office of speaker and deputy speaker, it will be vacant. Okay, this particular seat is also, gone. So we can say that yes, the Speaker of Legislative Assembly will vacate his or her office whenever the their seats of the state legislative assembly is getting seized. It is similar to the Lok Sabha actually. If you see, in case of Lok Sabha, we have speaker and we have deputy speaker. So just like the state legislative assembly, in the central level we have Lok Sabha, right? So in case of the speaker and the deputy speaker of the Lok Sabha, they also have the same, provision given by the constitution. What is that? Like whenever their Lok Sabha seat it gets seized, then their particular office of the speaker or deputy speaker will also get a vacant. Okay, so we can say this particular statement is a correct statement. Whenever the legislative assembly is dissolved, the speaker shall vacate his or her office immediately. So here what they are saying is, we know that after 5 years it is going to be automatically dissolved, the legislative assemblies, and similar to Lok Sabha in the central, the Lok Sabha will be getting dissolved after 5 years automatically. But in case of, like, let's say the government is like not able to show the, it is losing the majority, then also there are possibility that the Lok Sabha or the state legislative assembly will get dissolved even before the 5 years. Okay, so whatever it is, whenever the state legislative assembly is getting dissolved, what they are saying is, this particular speaker, he will vacate the office immediately. Is that so? No. Whenever the state legislative assembly is getting dissolved, this office of speaker, he'll be in the office till the new state legislative assembly is getting elected, and till the new speaker is coming to the office. Okay, this is similar to the Lok Sabha. Okay, whenever the speaker, even after the Lok Sabha is getting dissolved, he will not immediately vacate the office. He'll wait till the new Lok Sabha is getting elected, and then he'll be vacating his office. Okay, so we can say that this statement is a wrong statement. So the correct answer would be A, 1 only. Next question. With reference to the Parliament of India, consider the following statements. Statement 1. A private member's bill is a bill presented by the member of Parliament who is not elected but only nominated by the President of India. Statement 2. Recently, a private member's bill has been passed in the Parliament of India for the first time in the history of India. Okay, option, which of the following are correct answer, correct statements. So, if you see here, they are talking about the, what do you say, private member's bill here. So we all know what is private member. Whenever in a, Lok Sabha, Rajya Sabha, there are some members of the parliament. They are ministers. Okay. So apart from these ministers, the other members of the parliament, they are called as the private member. Okay. So first statement says that a private member's bill is a bill presented by a member of parliament who is not elected by but nominated. They are literally saying that the nominated members are the, let's say, private members. Okay, they are saying nominated members are also called as private members. Is that so? No, private members are totally different from nominated members. How the other members who are apart from the ministers of the parliament, the other members of the parliament are called as the private member. Even though they are elected members or nominated members, no issues. Everyone who are other than the council of ministers, they are called as private member. So this first statement is a wrong statement. Then second statement, recently a private member's bill has been passed in the parliament of India for the first time in its history. So if you see, it's not like last the private member's bill, it has been passed in 1970. So recently a private member bill was not passed. At least this question was asked in 2017. Before that, there was no private member bill which has been passed recently. Okay, and they have given first time in the history of India. So almost like 13, 14 times the private members bill has been passed throughout the history of India. So this is not going to be the first time. And the last bill has been passed around 1970. So we can actually eliminate this statement because it is a wrong statement. Okay, because the private members bill has been passed like 13, 14 times. I'm not able to exactly remember how many times. You also no need to remember how many times. Only remember that many times it has already been passed. Okay, in the history. So it is not the first time. So we can eliminate this option. So what would be the correct answer? The correct answer is option D, neither one nor two. So with that, we have come to the end of this class. We'll be continuing this particular topic and we'll be doing another, part of this particular topic. So thank you, students. We'll see in the next class.